Hi, I'm Brian Brown, one of the founding partners in Brown Barron.
And I'm Leah Barron, the other founding partner at Brown Barron, and we are a law firm that specializes in nursing home neglect as well as medical malpractice and birth injury cases. And today we're going to talk to you about the mediation process.
That's right. Sometimes, almost every time, one of the first things our clients ask us is, are we going to have to go to trial or can we resolve this case some other way? Now, sometimes the lawyers on both sides can pick up the phone and talk to each other and go back and forth and try to settle the case for what is a fair amount. But other times, despite best efforts of the lawyers on both sides, for lots of reasons, the lawyers themselves can't do it. Maybe they disagree about the facts. Maybe they disagree about what the damages are. But sometimes you just can't agree. So what do? You hire a mediator. And a mediator is a person, could be a retired judge, could be a lawyer who specializes in mediation, who has special training in helping people resolve disputes. Judge or lawyer, the object of the mediation is for that person to try to bring the parties together and avoid the rigors that come after, avoid the rigors of a trial. So what happens? The mediator usually comes to the plaintiff's lawyer's office, and we separate into different conference rooms. And the mediator hears the positions from both sides. And of course, before the mediation, both sides give lots of materials to the mediator to look at. And he or she comes in and talks to the plaintiff's side first, and the plaintiff, being the person who's bringing the case, gives the mediator a demand to resolve the case. And then they go and talk to the defendant's room. And the mediator goes back and forth, conveying not just numbers back and forth, but also the good and the bad of both sides' case. And hopefully the parties are able to come to a resolution. Now, why would you want to mediate the case instead of simply going to trial? Lots of reasons. The first reason is certainty. In other words, if we go to court, 6 people who we've never seen before and you don't know from Adam are going to sit in that jury box, hear the evidence from both sides, and make a decision that could affect your life forever. And it's a gamble every time you go to court, no matter how good we think our case is. With a mediation, the mediator can help you reach a resolution that you know for sure when the mediation is over is going to end the case. And actually, there's an old saying, I didn't make this up. The best mediation is when both sides walk away a little bit unhappy. And by that I mean the defendant says to themselves in their room, darn it, we probably paid too much. And at the same time, we're saying, you know what, maybe we should have held out for a little bit more. That's the best settlement in a mediation, or best settlement in general. So certainty is the first criteria, the first benefit. The second benefit is cost. Going to trial costs a lot of money. Now, with a contingency fee case, you'll never have to pay the expenses outright should we not get a recovery, but the expenses will come out at the end of the case should we get a recovery for you. And if we don't have to go to trial, that means we spend less on your case, which means more of the recovery goes to you. So we have certainty, we have the cost, and we also have stress. Stress of a trial is immense for the clients and the witnesses and, yes, the lawyers. And by knowing what's going to happen, not having to sit up in the witness stand, not having to be cross-examined, that's a big consideration when deciding whether or not to go to trial. Mediators are great. They have special training in helping parties see the warts, the flies, however you want to phrase it, on their case, and really are excellent in helping parties come together. And it's an avenue that we here at Brown Barron often take when trying to resolve cases. And remember, About 98% of cases settle. Very few go to trial in every area of civil practice. And mediation is a way to help us resolve our cases.
That's right. And we do have a lot of experience with mediation here at Brown and Barron. If you have any questions about a possible mediation or about a potential nursing home negligence case, medical malpractice, or birth injury case, please feel free to call our office, and you can also visit our website and subscribe to this YouTube channel to learn more.